Boy, the anti-gunners are in huge trouble in Illinois, specifically in front of Judge Stephen McGlynn. I've taken a look at the over 100-page transcript of the oral argument whether or not he should enjoin the so-called assault weapon ban. And boy, oh boy, the anti-gunners in America are not going to like it. Stay tuned, we'll talk. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gunner, constitutional attorney, member of the U.S. Supreme Court Bar, and New York Times best-selling author. If you have not subscribed to the Four Boxes Diner Second Amendment channel, please do so. Show your love for the four boxes of American liberty. Okay, folks. In Illinois, as you know, there's a series of cases going on, but there's one in particular that I'm focused on. That is in federal court, in the United States District Court for the Southern District of Illinois. It's in front of Judge Stephen McGlynn, who himself is a firearms owner, who's interested in procuring a handgun permit to carry in the state of Illinois. Now, he is presiding over these four consolidated cases being argued. The primary case, or the lead case for the purposes of the caption, is Barnett versus Rowell. Now, in the Barnett case, there was an argument that just took place over whether or not the injunction, meaning the preliminary injunction, as you know, a preliminary injunction prevents the state from, for example, enforcing a particular law from the moment that that injunction is entered until the case is resolved one way or another and there's a final judgment. So they're fighting about a preliminary injunction right now, whether or not the Illinois law can be enforced during the pendency of that case in the federal court in the Southern District of Illinois. Now, Judge McGlynn is unusual among other federal judges in the sense that he's actually a gun owner and is familiar with firearms. He was appointed to the federal bench by President Trump. So he's a little bit different postured than a lot of these sort of anti-gun liberals we see in urban areas like New York City and Chicago who don't know anything about guns from other than what they read in the New York Times or the Chicago Tribune, which may not be entirely accurate. With that said, let's talk about what happened. It was a hugely great day for the Second Amendment in front of Judge McGlynn. Of course, he made it clear he's not saying which way he's going to rule, but if you look at his questions and you look at how he beat up the lawyer for the state of Illinois, I have to say it looks very good for the Second Amendment, only time will tell. So a few things happen. Again, the Illinois law being challenged, the so-called assault weapon ban involving so-called assault weapons, which are semi-automatic rifles, and of course magazines that hold more than 10 rounds, the standard stuff by the anti-gun community passed by the legislature in Illinois. Now, right off the bat, the state defendants must have known they were in huge, huge trouble in this case because they argued during this oral argument that they talked about a .69 bore or a .69 caliber was a common musket size during the Revolution. And what's interesting is that Judge McGlynn volunteered, believe it or not, that Washington carried a .56 caliber pistol. That's right. So all of a sudden, the state realized that they were talking to someone that actually understood the difference between a barrel and a bore and understood what calibers meant when it comes to ammunition, which of course, once people really understand gun technology and gun history and gun law history, we are in much better shape because the judges that know none of this stuff can easily be propagandized into thinking that these are somehow special weapons because they're ignorant. And that's one of the reasons why I do this Four Boxes Diner channel, to try to educate the elites in society about these things because they're making decisions about guns, but a lot of them know nothing about guns. So I'm trying to talk to them, among others, about the importance of these issues so they understand and make the right choices in their world. But let me carry on with Stephen McGlynn. Very powerful stuff here. At some point during the conversation, if you look at the transcript, I'll put a link to it down below. You can check it out yourself. It's quite an interesting read. There's a colloquy going on between the state of Illinois and Judge McGlynn about concealed carry permits, and I thought this is hysterical. Specifically, the judge asked, what is the turnaround time to get a carry permit in Illinois? And the state of Illinois counsel had confessed that it's not as, this is what he says, it's not as quick as it should be. Well, the judge said, quote, mine has been pending since September. Woo! That is bad news, right? Here you have a federal judge who's already been vetted 6 ways to Sunday with the FBI and the Senate Judiciary Committee and the full Senate, not to mention the White House counsel's office. This guy's been vetted 6 ways to Sunday before he was ever nominated to the federal bench. And yet here he is waiting since September to get a carry permit in Illinois when he's the United States District Court judge in Illinois. presiding over criminal cases where he's putting away bad guys and drug dealers and the like away for decades. You would think, if anyone, you would need a concealed carry permit. Obviously, everyone's entitled to one under the Second Amendment. You would think that this guy would be to the top of the pile, and yet his concealed carry permit in Illinois has been pending since September. That's Judge McGlynn. So I thought that was also bad news for the state of Illinois, that here you have a federal judge who's pending concealed carry permit has been pending since September, and we're now in April. That is telling the judge quite a bit about the realities, and they can't snow him with statistics because the judge is living his experience of not being able to get his carry permit in Illinois. Bad news for the state. Then there was a discussion about rate of fire, and the judge pointed out, unprompted, the story of Lee Harvey Oswald's assassination of President John F. Kennedy. Specifically, the judge literally said that this assassination took place with this $19 bolt action rifle and scope. It was an Italian rifle, of course, that was used with 6-round magazines. And then the judge went on to speculate what would have happened if someone wanted to engage in a mass shooting using this kind of a $19 weapon from the 1960s, given that Lee Harvey Oswald's results on a moving target, upper body shots at over 100 yards. He went on to say that obviously the harm could be quite severe with this bolt-action Italian rifle from the 1960s, and basically saying that there's nothing unique or special about these AR-15 semi-automatic rifles. They're no more dangerous or less dangerous than what was used by Lee Harvey Oswald, which really tells you that this is a judge that understands firearms technology. And as I've said, if judges understand firearms technology, we are dramatically better off because they cannot be duped by anti-gun propaganda about what is not true involving firearm technology. But let us carry on. We know that the anti-gunners like to talk about AR-15s and label them as highly lethal weapons of war, but at the same time, they're useless for self-defense. So this is a little bit of a dilemma for the anti-gunners, right? Because if they're terrible weapons of war are not just, protect the soldier, right? Of course, AR-15s are not weapons of war, but the point is they're either weapons of war and very lethal. But if that's true, why would they, in theory, be useless for self-defense? You can't have it both ways, and the judge immediately picked up on this. This is why, of course, as you know, in other contexts, Joe Biden has said you should use a shotgun. Judge McGlynn did a great job on what I'm about to say involving this notion of a shotgun versus an AR-15. He talks about a hypothetical, which judges do all the time, talk about hypotheticals. They want to understand the scope of the law and what it should be. This is what Judge McGlynn asked. He says, what happens where a man gets a call from his wife and the man is away, and the wife says, quote, this is not me, by the way. This is Judge McGlynn, federal judge, Southern District of Illinois. This is what the judge asked, quote, "Oh my God, there's men outside. I think they're going to attack. Yeah, I can see it from my Ring telephone. I can see it on my cell phone." And she says, "I'm at the gun safe. I can pull the pump action shotgun that has 3 rounds, a gun that your experts are suggesting is the gold standard for self-defense in the home. Or I can pull the AR-15 and I can insert the 5-round clip that's loaded. Or I can insert the 30-round clip that's loaded, or should I say magazine. Don't you say, sir," and this is what Judge McGlynn asked, "don't you say grab the AR-15 and take the 30-round magazine because there's 4 of them, and the shotgun, while that's ideal, there's only 3 rounds in it, honey, and you're going to be panicked, and you can't assume that every shot you get off is going to be a lethal shot at first." That's not Mark Smith. That's not the Four Boxes Diner. That's Judge McGlynn, a federal judge in Illinois who understands guns, asking this question of the state of Illinois. I think that's very powerful, and I think this is a transcript that may make the rounds and circulate in various quarters in the American judiciary because it's such a great series of questions and somebody who really understands firearm technology, and that's important because, of course, the reason why people want more capacity in their magazines is because it gives you more opportunities for self-defense. Keep in mind that the nut job psycho in Nashville, I think, shot over 150 rounds. Well, if the bad guy is going to shoot like over 150 rounds in a mass shooting, why am I being limited to 5 rounds or 10 rounds? I want as many rounds as possible to be able to shoot back. So if they get to shoot 150 rounds, why would we want my capacity to be able to shoot back and defend myself to be any less than that, right? I mean, to be as much as possible. And moreover, keep in mind, as I've always pointed out, that the crazy psychopathic criminal always has the advantage because they act first. right? I'm sitting at some restaurant hanging out, or I'm at home hanging out watching TV. I'm not anticipating a gunfight. The bad guy shows up and tries to engage in a gunfight. The only thing I'm going to be able to use to fight back is what I got with me. I'm not going to be able to reload. I'm not going to be able to get a different gun from another place. I'm there. I need more capacity because I'm the one reacting. And as you know, action usually beats reaction. So denying people who need to react in self-defense to these crazy people is frankly terrible public policy. And of course, all of this is unconstitutional. It doesn't matter if guns are good or bad. The fact is we have a Second Amendment, and these public policy arguments, as the U.S. Supreme Court says, doesn't actually matter at all. There's no interest balancing a pro or gun, or guns are good or bad. None of that actually matters. Nevertheless, it is good to have a judge talking about these issues to try to educate the public. I think that's always a good thing, even though constitutionally it's not relevant. I should also note there were some interesting mistakes made by the state of Illinois' lawyer, although I thought he did overall pretty good job. I didn't have any problems with the lawyering here on either side. With that said, it was interesting how he made a reference to M16 refers to military, but I actually think the M16, the M in M16 refers to model and not to military, but the judge didn't say anything about that, although the judge is probably aware of that. The next interesting colloquy between the state of Illinois and Judge McGlynn dealt with flash suppressors. As you know, flash suppressors are used to basically minimize the risk of blindness when you're engaging in when you're firing your gun either at night or shooting the gun multiple times, whatever it is. But basically, it's trying to, you gun guys know it better than I know, it's trying to protect you from temporary blindness. But what's interesting is that the state of Illinois was arguing that, quote, flash suppressor stabilizes the firearm during periods of rapid fire. This is not true. Judge McGlynn immediately knew it. He jumped in and said, stop. Really what it does, of course, it prevents muzzle blindness, flash blindness from, among other things, during periods of rapid fire. But the judge also added, this is very interesting from Judge McGlynn, it shows you he knows his stuff, quote, or during a period of a single fire, pull of the trigger. So if someone's being attacked in their home, it's nighttime, and they fire their gun and it has a flash suppressor, it reduces the amount of interference with their vision from the flash, does it not? That was the question, not from Mark Smith. That was the question from Judge McGlynn, a good question at that. So I think the point about the flash suppressor the judge was making is this is not some scary, evil device. This is actually, of course, a very valuable tool for Americans using their firearm for self-defense in the home, which they're entitled to do under Heller and Bruin, among other things in the Second Amendment. And he was just pointing out that flash suppressors are a useful device when it comes to using your firearm for lawful purposes under the Second Amendment. Now, to summarize, the state of Illinois has run into a buzzsaw, as I see it with Judge McGlynn, because a lot of their usual arguments that judges across the country will just take at face value because they don't know better is not going to fly with this judge because, again, he's familiar with firearms, and that makes it very difficult for the anti-gunners to get where they need to be because once people understand firearms, it's very hard for them to justify the things they're going to do, and this is quite significant. So although Judge McGlynn at the very end of the argument said, look, I don't know what I'm going to do. It's not my job to make public policy arguments about firearms in America. It's my job to determine whether or not what the state of Illinois is doing in this case is consistent with the text and the history of the Second Amendment, and that's what I'm going to do, and I appreciate your time. So that's how Judge McGlynn wrapped it up. Only time will tell. We should get a decision soon, but I think it's very telling and a good sign that Judge McGlynn asked these kinds of questions and had this back and forth with the state of Illinois' lawyer. And as you know, the way this case should come out is quite simple, that AR-15s and magazines are arms under the Second Amendment's right to keep and bear arms. And because they're arms and they're in common use, meaning tens of millions of Americans have these things in their possession, which means they're using them, clearly it should be a very easy case for Judge McGlynn and the federal courts to declare that this assault weapon ban is unconstitutional and the ban on magazines is also unconstitutional. This should be an easy layup case, but only time will tell. We'll see what the decision says when it comes out soon. Okay, folks, I hope you learned a little bit something here today. If you haven't subscribed, please do so. We'll see you again here at the Four Boxes Diner.
Orders up. Table 2A.